First, let's talk about the RTI amendment bill that you introduced in the Lok Sabha on Friday. Now, this bill empowers the government to frame rules to decide salary, tenure, and allowances of information commissioners. The opposition has alleged that this particular bill will weaken the entire institution of Information Commission. How would you respond to those allegations?
No, I think before I say anything more, let me at the outset make it very clear. There is absolutely no intention, not at all, to weaken the RTI Act as such. And I think the commitment of the Modi government and that of Prime Minister Shri Narendra Modi himself personally to bring in as much transparency as possible with maximum governance, minimum government is unmatched. And the entire focus in the last over 5 years has been on transparency, on citizen centricity, on the ease of governance, which also would in this case imply ease of the delivery of RTI. And therefore, as far as the prerogatives, the privileges and the powers or the authority incumbent on the RTI Act is concerned, there's no change at all. In fact, it might become more effective. And over the last 5 years, I use this opportunity just to make the viewers also recall, we have in fact taken a number of decisions to make RTI more effective, more convenient, and to bring in ease of the RTI delivery. For example, it was an act where you could file an application to the Information Commission during the office hours. We made the best use of the technology, and today we have a mobile app. Anybody can file an RTI application any time of the day or night. Even after midnight, suddenly you get a thought, you can wake up and file an RTI. We have opened up a number of call centers to educate people, to make them aware of how best to make use of it. So that's one part of it. I'm talking of as far as the commitment of the Modi government is concerned to bring in more of citizen centricity, including that of the right to information. And yes, not only that, we have Section 4 in the Right to Information Act, which was brought in 2005, which expects the government to take suo motu cognizance of the information available in different departments and put it on the website. In fact, it is in the last 4-5 years that this clause has been taken very seriously. And now the state of things is such that even, for example, the DOPT, which you are referring to, and I also happen to deal with, even before a copy of an order, whether it's that of an empanelment or a promotion or transfer, reaches the concerned official is already aware of it from the website. So, as far as our commitment is concerned, there is no reason why it should be questioned. On the contrary, as you rightly mentioned in your opening remarks, this is an enabling legislation to bring about certain administrative structural reforms in the institutionalizing of RTI. So in a nutshell, I would say this is meant to streamline RTI Act, this is meant to institutionalize RTI Act, and this is meant to make the delivery of RTI easier. Secondly, also, let's not forget that there have been anomalies, possibly because I don't want to say that, but maybe the RTI Act at that time in 2005 was done in a little haste, or maybe out of enthusiasm. I mean, to look at it positively, I don't wish to be critical about anybody, even of our predecessors. Maybe in their enthusiasm, they left out certain missing links. And one of them was that there is no provision to frame rules in the RTI Act as far as the appointment and the tenure and the salaries, etc. of the information commissioners are concerned. So, as a result of that, as a consequence of that, while on the one hand the Information Commission is a statutory body, it's been almost made equal to a constitutional body like the Election Commission of India or the Supreme Court of India. And to simplify, in simplistic terms, I'll give you an instance. For example, the Chief Information Commissioner or the Central Information Commissioner is equivalent to the Judge of the Supreme Court by way of being equivalent to the Chief Election Commissioner. But the verdict given by him is challengeable in High Court, which is in a lower court. So that itself is an anomaly of the jurisprudence of the legal processes. And certainly the Constitution of India very well defines and demarcates the statutory bodies, the constitutional bodies, the regulatory bodies, and there cannot be an overlap. So in order to streamline, as I said, and to make it more effective and to make it more smoothly functioning, this amendment has been sought to be brought in.
But also, sir, a few opposition parties on the floor of the House said that this particular bill will attack the federal structure of the country.
No, I don't know what makes them so, what makes them feel so, because on the contrary, even if you see from a general perspective in the last 5 years or so, everything has been done to strengthen the federal structure. And that is something which could happen only under somebody, under a prime minister like Shri Narendra Modi, because who had had the experience of being a chief minister for over a decade, and at times when the federal structure was hardly cared for, and therefore he was at the receiving end of a number of non-federal decisions being taken at the center. Can we forget that the GST which was brought in had a council which had representatives from each and every state of India, including the union territories, and I must appreciate the Modi government, the Prime Minister Modi's guidance, and the then Finance Minister Arun Jaitley's diligence, that each and every decision taken in the GST was done unanimously. Even with the cognizance or the endorsement of those of the states which were run by parties which were not owing allegiance to the BJP, which was the party at the center. So what more can be the kind of respect or reverence that this government has given to the federal structure of India? Secondly, it is this government which increased the state's share from the revenue generated. So I think all measures have been taken in the direction of, in fact, strengthening the federal structure. Now, as far as the RTI per se is concerned, this legislation, as you rightly mentioned in the beginning, has a very limited purpose. It seeks to amend Section 27, which would authorize the government to frame rules. And it also seeks to amend Sections 13, Section 17, which are dealing with the tenure and the salaries, etc., the terms and conditions of the offices held by the members of the commission. So it is absolutely nothing to do with the federal structure. On the contrary, let's not forget the RTI Act of 2005 itself is through the residuary powers of list 1 of the constitution, which is neither the state list nor the concurrent list. And therefore, the act which was given to us by the UPA, which is namely the RTI Act of 2005, itself makes it inherent that the rules or the amendments or the legislations for the RTI or for the information commissions of the states have also to be done by the center. So it's they who gave us, and we are absolutely not making any change in the constitutional spirit or the soul of the act.
So there's no change in the soul of the act. Well, let's